Today's matter is very, very important. Please note down white paper and one pen. Please note down for your practical purpose. Today's topic is jurisdiction. So, which court?
Good evening, sir.
Good evening. Please note down white paper and pen. You should be keep along with you because it is very, very important topic today for practical purpose. Whoever advocate may be, they are coming to the practice before any court. You have to must understand which jurisdiction and what case we are going to file before which court. That matter you should note down because each courts I am going to explain for you because tomorrow you are coming from rural side and somebody is coming from Bangalore, and what are the jurisdiction of the courts are available where we have to file the cases. That is very, very important topic today for you. So you please note down. First, we want to go from Bangalore city. Yes. In Bangalore city, this is class 1 city. And
Good evening, sir.
good evening, good evening. And we are going to file a suit. Any suit we are going to file, it is deal with relating to pecuniary jurisdiction, means the amount which is going to be curtailed for our jurisdiction. So therefore, monetary cases which we are going to file before the Bangalore City Civil Court, that is called as original suit. So original suit which are having jurisdiction, whatever the valuation we are going to make before the civil court, based on the valuation, the courts are meant for. Suit is concerned for recovery or the valuation of the property. First, we are going to file original suit before the city civil court relating to the immovable property is concerned. If you are going to file a suit for declaration, if immovable property is going to be value more than 10 lakhs and above, that is jurisdiction lies before the city civil court, you have to file suit for declaration, and any other suit you have to file only based on the valuations pecuniary jurisdiction. So now, if you want to file a declaratory suit in respect of declaration of your property and its value is more than 10 lakhs rupees and lesser than 10 lakhs rupees, in Bangalore city, it is original suit only. So when the suit has been filed, OS, if failed in getting relief, any relief, so where we should file appeal before the Honorable High Court only, that is called as regular first appeal, RFA. If original suit more than 10 lakhs rupees, RFA going to be filed before the divisional bench, DB, lesser than value of 10 lakhs, it is going before single judge, RFA, under section 96, which is going to file against the order of original suit from Bangalore city. Directly first appeal is available before Honorable High Court of Karnataka from original suit to RFA, regular first appeal. Now, during pendency of the suit, application filed along with the suit relating to, please you see that this is suit before RFA. During pendency of the suit, some of the applications we are going to file, that is called as 39 Rule 192, that is injunction order. If you want to seek, if it is rejected and you are going before the Honorable High Court of Karnataka against that order, that is miscellaneous first appeal relating to appealable orders, which is laid down under Order 43, Rule 1. There are several appealable orders are mentioned. So one of the order, that is 39 Rule 192, restraining the defendants from interfering into the suit schedule property or from alienation of suit schedule property. If that application is rejected, only the miscellaneous first appeal and another application we are going to file along with that, because the another application for production of document, for appointment of commissioner, or for rejecting the application. If any applications are rejected other than 39192, it is questionable order in writ petition only. So you note down, I am dealing with City Civil Court, Bangalore. That is City Civil Court from where appeal lies, how the pecuniary jurisdiction has been fixed. So therefore, OS, if original suit, if we are going to file, that is pecuniary jurisdiction more than 10 lakhs or within 10 lakhs for declaration relating to movable or recovery of money or anything based on jurisdiction wise 10 lakhs and above, all the amount is available before the City Civil Court and appeal lies before the Honorable High Court of Karnataka in RFA. More than 10 lakhs means if 10 lakhs valuation you have made, it appeal lies before the divisional bench. Two sets of appeal you should file along with the pecuniary jurisdiction before the divisional bench, and if it is single bench within 10 lakh rupees, it is lies before the single bench RFA under section 96. Please note down, because why this pecuniary jurisdiction has been fixed, because it is since from High Court rules, City Civil Court rules, it is binding on the all the regulations. So therefore, this is pecuniary jurisdiction based on monetary transaction. So OS against the order, you have to file appeal under section 96 of CPC. That is the called as regular first appeal. And if any IA, that is 39 Rule 192 and appealable orders along with the suit are mentioned at order 43, and for which you have to take advantage of appealable orders. So that is called as MFA, miscellaneous first appeal. While pending suit, if any application rejected, 39 Rule 192, automatically you have to file miscellaneous first appeal before the Honorable High Court of Karnataka. And after completion of the evidence or everything, if the judgment is passed, any decree or dismissed, appeal lies RFA, that is based on the pecuniary jurisdiction, lies before the bench. After 10 lakhs, it is before the bench. Two set of appeal you should file before the High Court. After High Court, if anything is happened in RFA, you are entitled to file only special leave petition, that is civil appeal before Honorable Supreme Court. This is for city is concerned. So you please note down RFA, OS, RFA, and SLP. This is appealable orders when the judgment and decree passed, either in RFA, either in OS. So likewise, hierarchy of the courts. First, original suit, pecuniary jurisdiction, appeal lies before Honorable High Court of Karnataka. If more than 10 lakhs before the bench, it is going to be filed, and up within 10 lakhs, it is single bench before Honorable High Court. And later, you have to file, if anything is happened, you have to file special leave petition in civil appeal before Honorable High Court, Honorable Supreme Court of India. This is hierarchy of the in original suit. If any IA is dismissed except the 39 Rule 192 and other appealable orders, small orders, that is going to file only MFA, miscellaneous first appeal. So, likewise, we have to move the matter before Honorable High Court of Karnataka from Bangalore city, because wherever it appears original suit, we are going to file. And some of the cases going to file before the Karnataka Rent Act or small cause within 5 lakhs or within 2 lakhs, small cause court is having jurisdiction for deal with Karnataka Rent Act, wherever fixing the jurisdiction based on the measurement of the rented premises. So therefore, we are also filing eviction petition as well as this the easement suit going to file before that court also. So based on the pecuniary jurisdiction, if the small cause court, if we are going to file, this is appealable before Honorable High Court of Karnataka. So that is in CRP only, civil revision petition. So likewise, this is the jurisdiction of Bangalore city. So now note down Bangalore rural side. How you are going to file rural side. First court, civil judge junior division. The pecuniary jurisdiction is only 5 lakhs rupees, not more than that. So those suits which are going to file before the civil judge junior division, they are permanent injunction, declaration, the value is lesser than 5 lakhs rupees, then we are going to file before the rural court, that is called as civil judge junior division. If any failure on the civil side, that is rural side, before jurisdiction, that pecuniary jurisdiction within 5 lakhs, the appealable order is before the senior civil judge, that is senior civil judge up to 10 lakh rupees. Up to 10 lakh rupees, the appeal is lies from the JMFC or junior division of civil judge. Appeal lies before only the regular appeal, that is called as RA. What I have told in city, RFA, regular first appeal, but whenever you are failure in civil judge junior division, automatically the appeal lies senior division within 5 lakhs rupees, which are dealt by the rural court. So therefore, RA, that is regular appeal under section 96 of CPC, from civil judge junior division to regular appeal lies before the senior civil judge. So now, what is the jurisdiction of senior civil judge? Whatever the valuation going to make above 10 lakhs rupees, it is immaterial. About 10 lakhs rupees, it is fixed. 5 lakhs for the junior division, senior division is 10 lakhs, more amount, whatever it may be. Then that original jurisdiction before the civil judge. So therefore, civil judge is having jurisdiction, whatever amount, it is fixed. But against the civil judge junior division, appeal lies before the district court, wherever the restriction kindly may be note down, pecuniary jurisdiction has been fixed. 10 lakhs rupees senior civil judge. Within 10 lakhs, the appeal lies before the district court within 10 lakhs. If more than 10 lakhs, again you have to go before only RFA, that is rural side, from civil judge senior division. If any valuation more than 10 lakh rupees, you have to file appeal RFA, regular first appeal under section 96. Now you see that how the hierarchy, junior civil judge to senior civil judge 5 lakh, and senior civil judge having jurisdiction 10 lakh rupees only or more amount. Any amount, if you have valued more than 10 lakh rupees, appeal more than 10 lakh rupees, appeal lies before the Honorable High Court. If lesser than amount, that is lesser than amount 10 lakh, appeal lies before the district and session court, that is called as RA, and whatever more amount, if it is filed, and it is going before the High Court, Honorable High Court. Now, one case, one example I have dealt yesterday. Two suits I have filed from Karwar and Markera. What happened? The recovery of money suit has been filed before the senior civil judge. It is 14 lakhs rupees and Markera case is 18 lakhs rupees. The two cases they have got it filed from me. Appeal lies before Honorable High Court of Karnataka. Now, difference kindly may be looked into. Senior civil judge 14 lakh rupees recovery has been ordered. That is judgment and decree I have questioned before Honorable High Court of Karnataka in RFA, regular first appeal, that is under section 96 of CPC. So therefore, because pecuniary jurisdiction it is come across, so therefore I have filed RFA from Karwar stating that 14 lakh rupees valuation has been made before the trial court. Therefore, we have to file the jurisdiction wise, we have to file RFA before the division bench only, because more than 10 lakh rupees, even single judge is not entertained and it is automatically return the RFA and permit us to file before the bench only. Two set of appeal we have to file based on the pecuniary jurisdiction, because appeal is not lie. Appeal is not lie before the district and session judge, because across the 14 lakhs rupees, 10 lakhs rupees more. So therefore, appeal lies before the Honorable High Court of Karnataka, that is RFA. And another case also I have filed. We got the interim order. So stating that to stay the judgment and decree passed by the appellate court, because it is first appeal before this honorable court, and we got order because original order has been passed by the senior civil judge, and that matter is posted before the bench. Therefore, you have to see, idu ಮಾಡಿ silent ಮಾಡಿ, please, Santosh Kumar, silent, please. So you see that this is the fact. You have to mention rural side how the pecuniary jurisdiction has been fixed. Pecuniary means based on the valuation only. Civil judge, junior division, senior division 5 lakh rupees, appeal lies senior division within 10 lakh rupees. And if it is more than 10 lakh, automatically the suit can be filed before the civil judge from the rural side, and whatever amount, if it is going to be mentioned in the civil court, civil judge court, and the more valuation, if the appeal, if you want to file only before the Honorable High Court of Karnataka, more than 10 lakh rupees, or otherwise within 10 lakh rupees, it has to go before the district and session judge. Because this, why this type of pecuniary jurisdiction? Because you see, the valuation arises relating to partition suit. Civil judge, now one land, already 2004, the valuation has been fixed. 1 acre is concerned, more than 40 lakh rupees has been mentioned. So partition, if 4 persons are there, 10 lakh rupees each. So therefore, how the pecuniary jurisdiction is going to be valued about the property is concerned based on the SR value, that is sub-registrar value or the government notification. That valuation going to be arrived based on the pecuniary jurisdiction of the properties are concerned. So therefore, one of the plaintiff going to file for partition, and he is claiming the total value is 40 lakhs. So 10 lakhs rupees available. 10 lakhs it is available before senior civil judge. and he is going to file the partition suit. And then he has to file appeal. If he failure in getting the judgment and decree, he has to file appeal before Honorable High Court of Karnataka. Only RFA, that is 10 lakh rupees. If within 10 lakh, automatically lies before the Honorable Single Judge, or if more than 10 lakh, automatically liable for appeal before the bench. So this is the from rural side is concerned. Now, another question is arose. Once again, the same thing. If IA filed along with the suit, now you want to question that IA. Now injunction order has been rejected. If injunction order has been rejected to you, so automatically that order going to be questioned before the regular before the miscellaneous appeal, MS, that is before senior civil judge, from junior to senior civil judge, or if senior civil judge to district court only, then again MSA, that is miscellaneous second appeal before high court, likewise against the IA. And in any court, any other IAS, if permission to file the application or permission to file the objection statement, if it is rejected, limitation is barred and limitation application is rejected, you have to file only before Honorable High Court of Karnataka in writ jurisdiction, that is 226, that is the supervisory jurisdiction, and whatever IA has been filed, you have to file before the Honorable High Court of Karnataka only. Now, next, another question is there. You see, Order 7, Rule 11, the plaint going to be rejected. If plaint is going to be rejected, what is the remedy is available for you? If plaint is rejected, automatically you have to, because it is a judgment, it is a decree going to be issued. If it is rejected, plaint is rejected, automatically you have to file RFA, regular first appeal. If your application is rejected, for rejection of plaint, you have to file civil revision petition before Honorable High Court of Karnataka. This is the jurisdiction you must know. What are the grounds you have to raise, and what are the facts you have to communicate in the appeal, and what point of law you have raised. All these things you have to raise. Next, one more jurisdiction available for you. If RA, regular appeal, if it is dismissed by the senior civil judge, so where you have to go, only High Court, Honorable High Court of Karnataka, RSA, regular second appeal under section 100 of CPC. So RSA you have to file. In RSA, if both courts concurrent finding, that is called as word, if the both court is not given any relief, who has you see that now what I have submitting it to you, please note down, these are the jurisdiction wise, because pecuniary, based on the pecuniary jurisdiction only, we are dealing with the subject, and you have to take chance of recording yourself how you want to practice in civil court, either Bangalore city or rural side. So therefore the differences is available, and for which you have to take advantage of that. RSA, I have just now I have told you, from civil, from rural court, from civil judge, junior division, failure the suit, and you are going to file RA. RA is also failed. So therefore you are going to file regular second appeal under section 100 of CPC. So likewise, these are the jurisdiction you must note down while coming to the court. So why this RSA, RA, RFA, why all these things? Because you should not confuse. Today only you have to start to say that which are courts are having jurisdiction and which are courts are appealable courts, or you have to take advantage of that today onwards only, because why you are coming after 3 years, you are coming in practice. So suddenly you are going to appear before the High Court. How the appeal lies? You must know appeal from where it comes. So because when in those days when I was started the practice, I come across these are the big books are available for us. You go and read this RSA appeal, then only you realize about the jurisdiction. Our seniors are given our books, that is paper book, RSA paper book, regular second appeal. In that book, what it available from trial court, appellate court judgments are available, and again the appeal is available. What are the grounds raised in the second appeal? In judgment is also available. Two courts judgments are available. Two issues are framed in the both courts. In appellate court, points are framed to decide the appeal, and subsequently in RSA, substantial question of law. What the court ought to have to decide the appeal. Therefore, that is also available in RSA. So therefore, we have provided opportunity to read regular second appeal because two courts judgments are available from trial court, appellate court, and appeal is available. Along with that, every exhibits documents are available in the paper book. So therefore, you have to read those books because while you are entering in any office, first you take out the RSA or RFA, how it has come and from where it has come, why the appeal has been filed before the court. So therefore, on the ground of pecuniary jurisdiction, you have to assess why this appeal has brought and what for it is. So therefore, you have to note down these are the appeals and original suit based on the pecuniary jurisdiction. And another one thing you have to learn, you have to see, verify the MFA, MUC cases. In MUC cases, it is at Bangalore city, it is available before only small cause court. All the MUC cases dealt by small cause court because under notification it has been issued Honorable High Court of Karnataka. The small cause court is having jurisdiction to decide MUC motor vehicle accident cases. So those cases, MUC cases dealt by small cause court. Against any judgment passed by the small cause court, the appeal lies before Honorable High Court of Karnataka in MFA, that is miscellaneous first appeal, either for enhance, either for set aside the judgment, either for appeal going to file by the insurance company or anything. So that is appeal lies from the MUC court, it is MFA. Because another MFA, again in your mind, sir, one MFA you have told 39 rule 192, that is injunction order or stay order or injunction is not granted automatically under order 39 rule 192, that is appealable orders are mentioned in CPC, that is order 43 rule 1. So you have to read those orders which are appealable orders. CRP is available, civil revision petition available. Civil revision petition always in two cases, that is from HRRP, that is house rent revision petition, from small court. If it is rejected, house rent revision petition is available. In before the rural court, automatically it is CRP is available, revision petition before the appellate court, that is from small cause, civil judge junior division to higher court. So these are the functionaries, because if you are knowing fully well the jurisdiction, then only you can ascertain where we have stand, in which court we have to practice, in which court we want to learn something more. So therefore, from beginning itself, you must know what are the pecuniary jurisdiction, why the civil court, civil judge junior division, why the JMFC is mentioned. All these facts you must know. Now you see, in Bangalore city, the courts are available, that is traffic court is there, family court is there, Everything is available before the court. And so all these facts you must know where we should go before, in which court we are eligible to file appeals or suits. So you must know very well. So you note down all these facts relating to rural side and the city side. So what are the appeal lies? How the appeal going to be filed? So based on the pecuniary jurisdiction, IA is concerned. Always writ in IA relating to 39 Rule 192 MFA, and against the order of small cause court relating to MUC is concerned, you have to file MFA, miscellaneous first appeal. If you see MUC, so because in our office more MUC we have filed. So those cases always we are going to file the enhancement purpose. Now you see 10 lakh rupees has been awarded. It is lesser amount. It is not properly assessed. Therefore, we are going to file before the Honorable High Court of Karnataka miscellaneous first appeal MFA. So likewise, you have to ascertain yourself what is the pecuniary jurisdiction. You should not depend upon anybody. While you are going to office, you must note down, because for your sake only I am coming before this video, and I am coming because why I am coming to you, because of that the basic feature of your practice. This is the practice you have to render to the public at large. You should not say that I do not know what is what. The only one thing you have to do, if you are not aware, you come and ask in the office and sit one day. You collect the paper and collect the history. You must take down the note of their claim. Then only you can ascertain how, where I should file the case. And if you are not having such knowledge, you ask anybody else at Bangalore. They are all the senior advocates, they are going to cooperate you, because time may be granted to them. They are going to draft you and handing over the file to you. So therefore, likewise, you have to seek the jurisdiction based on pecuniary jurisdiction, based on the property jurisdiction. Property jurisdiction always, any suit you are going to file before the particular court where exactly jurisdiction comes. Now you can't file from Bangalore property to the Devnali court. The one jurisdiction is available for you. Anywhere in Karnataka, if you want, bring those properties. But one thing is must, the more properties are situated where, that is the criteria of assessing whether the suit is maintainable or not. If you see at Hubli, so many properties are available at Hubli, and one or two properties are available here. So therefore, these property can also include for partition suit at Hubli also, because more properties are available. So therefore, likewise, you have to assess the client's request. Partition suit, you need not bring the partition suit from more properties which are available at Hubli and bringing the suit only for particular property at Bangalore. So in one case at Nelmangla, I am the defendant in that case. What happened? Two properties they have included and more than 9 properties are there. These 2 properties, what they are claiming, I was one of the family member. I am a employee at Bangalore and I earned myself those 2 properties which are included in the Nelmangla case, because what their claim, whatever the earning arise out of joint family property situated at Nelmangala, and he has purchased these 2 property and put up construction. Therefore, it is also called as joint family property. It is burden lies on those who are filing the suit. So therefore, you see under the partition suit that is available right to claim. Wherever the more properties are available, the partition suit can be filed by including Bangalore property or anywhere else. So these are the jurisdiction you must know. And another one case, peculiar case is family court. Family court at Bangalore, wherever family court establishes, Mysore, Belgaum, Hubli, and wherever a city is concerned, there are family courts. All the appeal lies before the High Court only. All the appeal. So therefore, these are the relating to the civil jurisdiction. If any doubt arises, you please ask me again. Once again, I want to convince, because I want to go for criminal cases next. Yes, sir.
Sir,
Yes.
family court directly after filing the case in the family court, after that it will go to the session court or directly go to the high court?
Sir, before rural court is concerned, only what happened, arrangement has been
Hello,
made.
Zaman.
Arrangement has been made. What happened in family cases before senior civil judge is available. Jurisdiction is given by issuing the notice. Those family cases from rural court to session court, it will come, sir, not high court. But at city is concerned, wherever the family court act established, means Mysore, Belgaum, Hubli Dharwad, and Gulbarga, all the family courts are there. Those family court orders always questionable before only Honorable High Court of Karnataka, sir, Dharwad or Gulbarga or Bangalore, wherever it jurisdiction.
Thank you, sir.
Welcome. Suit is concerned, must note down the rural, civil judge, junior division, civil judge, senior division, 5 lakhs, 10 lakhs and above, and if more than 10 lakhs, district judge appeal is within 10 lakhs, appeal lies before the district court. More than 10 lakhs, automatically high court. That is from rural side. City side is immediately RFA, that is regular first appeal before the high court only, because whatever the amount it may be, even injunction suit kindly may be looked into. I have shown the injunction suit. I have filed several injunction suit restraining the authorities, restraining the defendant, and appeal. If suit is failure, automatically suit is failure or decree, automatically appeal lies before Honorable High Court of Karnataka only. That is city level cases, not for rural side cases. Rural side is having its jurisdiction based on the pecuniary jurisdiction. Pecuniary means assessment of valuation, money, 5 lakhs, 10 lakhs, then above the 10 lakhs, Honorable High Court of Karnataka is having jurisdiction. Yes, sir.
Sir, property is out of Bangalore, but person is staying in Bangalore. So the case has to be filed only in the property where it's situated?
Yes, sir. Because property is concerned. If any, I told you, no, the more property where it is situated, you have to file only relating to the partition suit. Declaration or fighting for questioning the sale deeds, all these available, particular jurisdictional area only. That is, if Nelmangala, all these Nelmangala case, you can't file before this court. Only relating to partition. If some more properties are available at Bangalore and 2 properties are available at Nelmangala, that property can be bring in partition suit, not other than that.
Sir, is this based on the valuation of the property or the number of properties?
Valuation, sir. 10 lakhs, 5 lakhs, 10 lakhs, and more than 10 lakhs, based on the valuation only. Original jurisdiction is available for rural side is concerned. Within 5 lakhs, you can file civil judge junior division. More than 5 lakhs, you have to, because you see, 8 members are there. And each member, they are going to get 4 lakhs rupees. It is, that suit is lies before only that civil judge junior division only you can file. Because each of them, they are getting 4 lakhs worth of property for partition. So you have to file suit before civil judge junior. More than 5 lakhs, you have to come before civil judge senior division.
Sure, thank you, sir.
Welcome, sir.
So one clarification,
Yes, sir.
if the case is lost at a lower court, even though the value of the property is less, can it go for the upper courts?
Yes, sir, definitely, sir. Any cases, you see, based on the valuation only. If injunction suit, just I want to tell you, if it may be 1,000 rupees, it may be crore rupees. If you have filed a injunction suit, if you have failed, valuation is not criteria for the injunction suit, because wherever the declaration, wherever questioning the sale deed, wherever the valuation is more, so you have to seek only pecuniary jurisdiction. But relating to injunction suit is concerned, only the civil judge, junior division only. It may be crores valuation, but injunction seeking against the defendant who is trying to interfere, who is damaging your property. So you can file injunction suit only. Because what happened in my case, more than 12 years, I have retained the case for injunction. And subsequently, the written statement has been filed, some of them. Our sale deeds are not questioned. We have purchased the property valuation. So therefore, when sale deed is not questioned, automatically the injunction suit is not maintainable, because we are denying the title of the parties. On denial of title and possession, automatically you have to question the sale deed as well as declaration suit, only the pecuniary jurisdiction. If about 10 lakhs, you have to file the suit before senior civil judge within 10 lakh, above the 5 lakh rupees, within 10 lakh, it is also civil judge having jurisdiction. You have to file the suit. More than 12 years, I have maintained the injunction order, and maintained status quo has been granted. It was continued. After lapse of 12 years, I have filed an application stating that I may be permitted to withdraw, because they are denying our title and issues are framed. Whether you are having position, you are in lawful position, because sale deeds are there. So therefore, I have made an application, permit to withdraw the suit, present the suit, comprehensive suit before the jurisdictional court. So I got the permission. I have filed a suit before the senior civil judge by valuing the property more than 8 crore rupees. So I have made, because it is agriculture land, 8 crore rupees worth. You need not assess the value relating to the agriculture property is concerned. Only that is the law is available for you. You may be assessed 8 crore, but the court fee is liable to pay only based on 24 times of tax what you are going to pay on the agricultural property. That is only the criteria difference between two other properties, immovable, movable property. Agriculture property is concerned, you have to value. If it is maybe 8 crores, but you can value for declaration any concern 24 times than the whatever the tax you are going to pay to the government. So that is the valuation. You can arrive and file a suit for declaration before any court. But more than 10 crores or 8 crores, automatically civil judge senior division is having jurisdiction. So I got the permission, I have filed the suit. Same 8 crore rupees still going on, because in that suit, comprehensive suit, cancel the sale deed I have asked, because it is my agriculture land. My sale deed is available, only agriculture land, but subsequent so many events are happened. After purchase of the property without our knowledge, automatically they got it converted, and it is value more than that. And whatever the pecuniary jurisdiction he has valued, it is lesser than value. Therefore, plaintiff is liable to pay tax, liable to pay court fee on that property. Then you need not worry about that, because whatever originality is available, you can assess the property based on that.
Thank you, sir.
Welcome. Is there any questions, sir, relating to jurisdiction wise? Civil court, city civil court, and rural court, all these facts You must know, because when you are entering into bar, first question they will ask, sir, why the Mehal court? Sir, why the rural courts available at Bangalore, sir, when it is a Bangalore city? Because Bangalore district, Bangalore urban district and Bangalore rural district, both courts are available at Bangalore. So rural places, because until and unless merged with BBMP, jurisdiction has been mentioned. So merged with BBMP, it is still it come the property within the rural court. You see, my one case is Electronic City. It is ward number 112, 192. Now till today, it is not within the jurisdiction of city, because it is still it is rural side only. So Bangalore rural district is having jurisdiction over that. So Electronic City property is comes within the rural side only, not in the city till today. So likewise, the extension of jurisdiction, the BBMP ought to have to say this is the not rural, it is comes within the urban area. So then only you can include the cases, you can file a cases before the city civil court only. Any question? Any doubt? Sanjay sir?
No questions, sir.
Thank
No
you.
questions for the moment.
So how you feel?
Yeah, well, with these sessions, sir, yeah, they are absolutely wonderful, sir.
Ah,
And yeah, we'll have to slowly build up our skill and knowledge base. So
yeah.
these things would certainly help us.
Yes, definitely. It is
Yes, sir.
practical purpose only I am saying. Immediately you are coming in the bar and you must not afraid of that. You must learn something, because you must see this is the knowledge you are gaining. So yes, our college president has told everything, this particular pecuniary jurisdiction, all these things. You must know why the small cause court, why the civil judge senior division, why the civil judge junior division, what are for, how it is meant for those cases, how they are going to file. All this you should be aware that, because it is very easy for you to learn something more.
Yes, sir. Definitely, sir. Yes.
Yes. Any other question relating to jurisdiction wise?
Sir, there are some things regard to executive magistrate. Those are like Tahsildar.
I will tell you for that. I will come later, because the execution comes under criminal procedure. So I will come for that also. Huh? So shall I go for further? Criminal jurisdiction.
Yes, sir.
Criminal law about the jurisdiction is concerned. You see, the JMFC, Judicial Magistrate First Class, and Civil Judge Junior Division. It is wherever the punishment is lies, 3 years, within 3 years, punishment is going to be imposed. Automatically, all the offenses, that is 324, within 3 years, the punishment going to be imposed within 3 years. All the cases, charge sheet, criminal offenses, everything lies before only judicial magistrate first class. Against that order, if any conviction, against that order, appeal lies before the district and session court. See, 2 things are available. Now senior civil judge is available, sir. Why can't they file appeal before senior civil judge? No, under the criminal is concerned, appeal lies from the after 3 years, within 3 years, any conviction order passed or any acquittal has been made. Acquittal is concerned, they have to file appeal before Honorable High Court of Karnataka, and recently some amendment was took place. Appeal lies before the session court only. That is acquittal under section 378, conviction under section or conviction under section 374. So both appeal shall lie before the district court and session court only. If yesterday one judgment has been passed, if session court conviction order has been passed, acquittal has been made by the trial court, session court conviction has been passed, set aside in the appeal, conviction order has been passed, that once again you have to file appeal before Honorable High Court of Karnataka. You see, against the judgment passed by the session court, you have to file, if it is convicted, you have to file criminal appeal only before the court. Previously, what we are going to file, civil revision, criminal revision petition, we have to file. But now, in law changes, because once conviction has been made, not upholding, because whatever the order passed acquittal, if it is questioned in criminal appeal, if session court comes to conclusion, yes, he is liable for conviction, setting aside the order passed by the trial court, automatically it will come before only High Court, that is criminal appeal, not CRP, not criminal revision petition. So likewise, it is available for you. This is the bail. And regarding bail petition is concerned, if the trial court is rejected, even 3 years, 420 offense is concerned, I think IMA, you know very well, the economic offenses. Likewise, if it is rejected, bail petition, you have to file only before Honorable High Court of Karnataka, and any other bail application rejected by the trial court, and that against that order, you have to file criminal miscellaneous petition under section 439 of CRPC. 439 of CRPC, bail application before the trial court, if it is rejected, and 439 is available for you before session court. And then only, if even session court rejected, Honorable High Court only dealing with 439, because he is in judicial custody, therefore it can be filed. And another one section is 438, anticipatory bail. Anticipatory bail always lies before the session court, not before the trial court, that is magistrate court or anything. Honorable, the jurisdiction relating to 438, anticipatory bail in the event of arrest, apprehension of arrest, they have to file criminal miscellaneous petition under section 438 before session court only. If it is rejected, again you have to seek anticipatory bail before Honorable High Court under section 438 only, for reasons shown in the rejection of the bail petition. You have to question that, not questioning the order, but you have to seek by filing criminal petition. There is an anticipatory bail, because in the event of arrest, there is apprehension of arrest. Therefore, I am entitled for the bail is concerned. This is one of the line. Now just now asked, sir, Taluka executive magistrate is Tahsildar, that is Dandadhikari. Just you see the board going before Tahsildar office, Tahsildar Mattu Dandadhikarigalu, that is executive magistrate. So those under KP, those under offenses which are 110G, tranquility, peace, who has made, who has trying to abet the people by doing some illegal functions, illegal acts, the Taluka magistrate is having jurisdiction up to section 144. All the cases comes within before the Taluka magistrate or district magistrate. District magistrate, the right, RIOT, right is concern made by the people. It is either Taluka magistrate or, and now always you think, always you see that the police is empowered, shoot the people whenever the raids are going on. Only the Taluka executive magistrate or the district executive magistrate, that is deputy commissioner. Only the two authorities they can order charge, lathi charge or the fire. So only these officers, not by the magistrate, not by the district session judge, Nobody has order passed because the tranquility, public tranquility, peace, peace is concerned. The only two judges are having jurisdiction to file the cases before the court. And wherever the criminal revision petitions are available, CRP, if any IA orders are passed by the trial court, that is magistrate court, that question, that IA order can be questioned only the district court criminal revision petition. If criminal revision petition failed, only 482 High Court, they have to go inherent power because the revision application has been rejected, that maybe pass the appropriate order. So likewise, you have to move the matter in the criminal proceeding. So appeal in murder cases, appeal against the district and session judge, wherever the more than 3 years offenses committed, all the cases are triable by the session court only. Against those orders, automatically appeal lies before Honorable High Court of Karnataka. So these are the cases, these jurisdiction which are fixed under the Criminal Procedure Code. Any doubt for you?
Sir, Tahsildar is same Dandadhikari?
Yeah. Executive, Taluka Executive Magistrate and Tahsildar, one and the same. And Deputy Commissioner and District Executive Magistrate, one and the same.
So Tahsildar and SDM, Subdivision Magistrate,
Yeah.
this Tahsildar is usually, Dandadhikari means the person who has the right to give the punishment.
Yes.
So I have a confusion that
So I
Tahsildar
think,
is usually work for land-related issues, right?
yes, not only land related, right? 100 and section 110, you go 144. All these cases, what they are doing, if any abatement made for the people doing some wrong decision, for atrocities, for doing some harassment to the public, which is going to be a harm to the public, and he is calling him to execute the bond, you should not continue the same, otherwise they are going to punish in accordance with law. That is available. Only what yesterday one case I fought before the Honorable High Court of Karnataka. What happened in my case, one Aklapa from Pavgada Taluk, what he did in the year 2018, he was punished for playing cards, 300 rupees punishment is there. Now subsequently, the head constable and sub-inspector reported to the higher authorities, means Tahsildar, saying that, sir, he is always abetting the people and disturbing the people and calling them to play the playing card in the public places, and nuisance is creating. So therefore, kindly maybe take action. That is punishment under section 110 E and G. That is abatement doing such acts. So in that cases, the punishment is what punishment? He shall be called and inquire into the matter. Immediately he calling him to execute the bond. He should not do once again the same illegal acts, abatement act or playing card act. That is the executive magistrate calling him for a period of 3 months or 4 months. And those cases shall be completed within a period of 3 months only. All the cases, all type of cases within 3 months to inquire, and punishment shall be imposed either to execute the bond, he should not do once again. So likewise, that is the law laid down under section 110, 144, all these acts are available. And one case is available for you, 125E, relating to the maintenance of parents, wife, children. That is 125. That is jurisdiction lies exclusively before only family court and as well as the civil judge JMFC court. JMFC court means judicial magistrate first class. They have to entertain the maintenance application, either parents or children or wife. All the 3 persons go before the JMFC court to claim maintenance against their sons, against the those who are depending upon them. So they are eligible for maintenance is concerned. That is 125 proceeding. Chapter 4 or 6 is available in CRPC. So that is the jurisdiction having by magistrate JMFC court relating to the maintenance is concerned. Yes, sir.
Sir, for the lathi charge or air charge, you said only Dandadhikari, Tahsildar
Yes.
or DSP or the Superintendent of
No,
Police.
DSP is not available. Even SP can't do until and unless ordered by Taluka Executive Magistrate or the Deputy Commissioner. No SP, nothing, even DIG can't do. Even IG of the state, he cannot order for Lathi charge. Only based on the direction of these two authorities, Tahsildar or the Deputy Commissioner.
But sir, Tahsildar also following the orders from those higher authorities, right, sir?
Sir, Tahsildar he is also executive magistrate, sir. He has to bring the peace in the public at large. So with the help of the police, but he can order for lathi charge. And also Taluka district deputy commissioner is also can order, but not the SP, not the IG. No police authority can order for lathi charge, sir.
Okay, sir. Thank you,
Okay.
sir.
Welcome.
One small confusion, sir.
Yes.
Regarding the anticipatory bail.
Yes.
Once your anticipatory is rejected by the session judge, do we need to take permission from the session court and then go to the 482?
No, sir. Only directly you can file after rejection. Because that rejection order is required before the Honorable High Court of Karnataka. You need not question that order. You see, always we are going to file appeal, questioning the order passed by so and so court. No, you need not question. But that order, you have to recital, you should mention in one of the ground, stating that learned Honorable Session Judge rejected the anticipatory bail on the ground that the punishment is going to be imposed by this court and there is a heinous offense and there is a chance of leaving the jurisdiction, or he is going to tamper the witnesses, therefore rejecting the cases. So that government is sufficient in the order, and however, the order passed by the session court is going to be placed along with this petition. That's all you can mention. But that order you cannot question in the criminal petition before Honorable High Court. Because jurisdiction 438 providing not only High Court, directly you can approach the High Court, but High Court what they saying, at least because the session court is first having jurisdiction, you go and approach because it is a concurrent jurisdiction.
Then in what ground we can directly go for 488, 482?
Because one of the case I have filed. So 482 you see, now Madras is Hosur case has been registered, criminal case. I am resident of Bangalore city. So I have made both the station as a party to the proceeding and also Home Minister, that is from the Home Secretary of Chennai. And before only High Court is having jurisdiction to directly you can file the 438 petition before Honorable High Court. Sir, this is the case has been registered at Hosur. I unable to get anticipatory bail because people are coming and getting assistance through the my police jurisdiction. The both police station you should be make. One is State of Karnataka Home Department. Another one is Home Department of Tamil Nadu, and also the police station in whose jurisdiction the case was registered, and also where you are residing. These are the 4 members you have to make an parties to the proceeding under section 438 before only High Court, not before the session court. That is, along with you have to mention 438 read with section 482 because it is an inherent power. They are granting the bail here and directing us to appear before that jurisdictional court. Till then, they should not arrest. That is also order I have taken so many times because one Calcutta case I have taken, One Gujarat case I have taken bail 438. Sir, I am going to surrender before that court. Till then, I should not harass, sir. This is the case between husband and wife. This is the case for 420 because cheating cases. Such type of cases you have to make both state government. The court will consider, sir. No problem.
Thank you, sir.
Welcome. Is there any other questions, sir? If you need,
So
I will guide for you.
You
Yes.
said from the district side, the DCP has the authority, right? I mean, he is the judicial magistrate there, right? DCP. So is it District Commissioner of Police?
No, 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 sir. DC, no DCP. You see, again you are mistaken. DCP comes within the here division wise they have made DCPs. One east, west, north, south, and central. 5 DCPs are available at Bangalore. Those DCPs are available at the rural side. They are called as SP, Superintendent of Police. Assistant Commissioners are available here. Those Assistant Commissioners are called as Deputy Superintendent of Police, DYSP, in rural side. So therefore, you should not think otherwise. DCP means SP in rural side. DCP means in civil, in city side. DYSP means rural side. Assistant Commissioner means city side.
All right.
Your doubt actually, DCP is different, Deputy Commissioner is different. Deputy Commissioner is of IAS cadre.
SP, that is Superintendent of Police. Always.
IAS cadre or ಅದು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಮತ್ತೆ DCP ಅವರು
ಅಲ್ಲಲ್ಲ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅನ್ನೋದು ಸಿವಿಲ್ ಸೈಡ್ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ಅವರು ಕಂದಾಯ ಮೀನ್ಸ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹೋಲ್ಡ್ ಇಸ್ ಎಸ್
He's speaking about police and he's confused about
no. See, DCP, Deputy Commissioner of Police, is 5 zonal has been made at Bangalore, east, west, north, south, and central. They are the DCPs who are the rank of IAS cadre. DCP means Deputy Commissioner of Police. Deputy Commissioner Jilladhikarigalu, that is Executive Magistrate, District Executive Magistrate, entirely differ from DCP and Deputy Commissioner.
DCP is IPS cadre, DC
Yes.
is IAS cadre.
Yes, IAS. And yesterday one judgment has been passed by Honorable High Court of Karnataka. I think you have read over in the paper. That is the additional DC or special DC, those who are upgraded from KS to that grade, is special commissioner and additional commissioner, promoting from KS cadre to that stage. Now they are not the deputy commissioner wherever it is laid down under the provision of Act. They have no jurisdiction to pass the order. Recently it has come. Now it is powers are withdrawn from them. I think shortly the government is going to abolish those cases, because either directly you promote him, he has reached IAS cadre, you designated as deputy commissioner, not as a special deputy commissioner, not as an additional commissioner. So all the powers, they are not the authorities under any Karnataka Land Revenue Act or Endowment Act or any other acts. So therefore, they have been defeated now. Shortly, they are going to withdraw the powers from them, because the High Court has declared they are not having jurisdiction to pass any order under the provision of Act, because they are not IAS cadre. Because why I am providing information All these facts are available for you. Tomorrow, where we should go, what is the inquiry, how the inquiry going to be conducted. All these facts you must know while you are entering into bar. So therefore, I am providing what are the, you see, the grant last week I have given the grant, who who are the authorities of the land grant rules. So they are the authorities. Likewise, you have to take advantage of that. Yes, any doubt, sir? Because what happened, one thing I want to advise to you, if directly you are having a vocabulary, you are having a good knowledge in English, some advocates, what they are doing, directly going to bar at High Court only. When they are realized, if they want to file a suit before the trial court, they do not know how to file. That is main problem. In one of the case, senior most advocate filed a suit before the rural court without showing the scheduled property. It was more than 12 years it was trial took place. No schedule was available. NOC has been brought. I have amended, got it amended. Sir, though the property is involved, but schedule is not available. Tomorrow, it is very difficult for execute the decree if it is going to pass. Schedule property, if without schedule property, how the decree going to be executed? Just imagine. So likewise, you must ascertain from the trial court. You go before High Court. I am not, because I have started my practice in High Court, but I have left the High Court because I must know from the beginning. Then only we can, well versed in the matter, we can address the argument in a good manner before Honorable High Court also. No problem. You waste your time before the trial court at least 1 year and 1.5 years. That's all. Because that purpose only I am providing all these basic things for you. You need not wait anybody else. You ask, you come out. Likewise, we are available for you. You collect papers from us and go ahead for practice. Right, sir. Anything you want, sir?
So public interest litigations, public interest PIL,
yes,
those we can directly file into the High Court.
Yes, sir. That is only, even I have more than 10 PIL I have filed from Gulbarga, from Dharwad. All the PIL shall be filed only before the Chief Justice where they are sitting. That's all. Not before High Court of Dharwad, not before High Court of Gulbarga. Only we have to file before Chief Justice.
Chief Justice means High Court, right? I mean.
No. Chief Justice. Now all the High Courts are independent now. Because Dharwad is also independent, Gulbarga is also independent, but PI lies before only the Chief Justice. Anywhere else in Karnataka.
So Chief Justice is also will be there in High Court only, sir.
High Court of Karnataka at Bangalore bench.
Okay, Bangalore. I mean, it will be in the capital of the state.
Yes, sir. And even if Chief Justice post is transferred to Gulbarga or the High Court of Dharwad, we have to file there only. Even at Bangalore, any PIL.
Got it.
We have to file. That writ jurisdiction I will come. Detail I will come. What are the writs are available? Writ appeal, how they are going to file. For that particular separate factor, because it is practical purpose from while you are beginners, you have to learn these pecuniary jurisdiction, where suits are filed, permanent injunction where we should file, and what are the valuation we are going to file. So for example wise, I am providing information to you. Which court lies, how much amount, I am going to provide chart to you in the college shortly, and that chart going to be prepared for you, because Immediately while you are coming, you must know where I should file, what type of cases we are going to file.
Okay, sir. Thank you very much.
Welcome.
So will you
madam.
be giving that chart to second semester students or?
Everybody from first, because you must know the jurisdiction first. So being a lawyer, sir, when I am coming for public purpose, we are helping the justice to the people, and you must know the basic things. Then only you can learn so many things. These are the
Sir, one question. This is
Yes.
related to some other state people like me. I am from Chhattisgarh. So how I can relate where different terminology is used, like
no,
panchayat,
nothing.
panchayat.
In all states, sir, in all states. Now only the name is different. High Court of Judicature, High Court of Chhattisgarh. Likewise, the name is only available like this. But jurisdiction-wise concern, the senior civil judge, then High Court, District Court, then High Court. Everywhere in India, sir, the same analogy is available for you.
Okay, sir. Okay. Because there is some panchayat, gram panchayat.
That is Gram Panchayat, sir. I will come later, because what are the jurisdiction of Gram Panchayat? That is Gram Panchayat. They are not judicial officers, sir. It comes under Panchayat Raj Act. Always every Karnataka State Panchayat Raj Act, Chhattisgarh Panchayat Raj Act, there are some jurisdiction, how the powers and functions are distributed to the president, vice president, or PDO, or executive officer. Everything is available in particular act, sir. I will provide those, because single act, if I comes, definitely I will provide the information. Everywhere same thing is available, sir. I have practiced at Krishnagiri. It is Chennai. I have practiced at even Andhra Pradesh. So I have gone Gujarat also. 138 proceeding, I went Calcutta and Gujarat.
Very nice, sir.
Yes, sir. Because experience is more required for you, because this is the stage, sir, for you. In our college, students, those who are coming for practice, they must know seriously. Yes, I know that I heard this matter, because you are coming and tomorrow you should not say, I don't know, sir, you please give me. No, today onwards, you must learn.
Yes, sir. Thank you, sir. Thank you for providing all this knowledge, sir. Very precious, sir.
Yes.
Thank you.
Thank you.
Sir, in the civil side, you said no, there are different benches, right? If less than 5 lakhs, then probably single bench.
Yes.
Between 5 so in the criminal procedure, I mean, we said it's below 3. It's any other bench required for any other.
Sir, economic offense is concerned. Economic offense courts are available, sir. IMA, Bangalore problem, you know. IMA, it is sent for economic offense court. It is punishment they can impose up to 7 years. That is jurisdiction they have fixed. Now, senior civil judge is holding those cases, sir, because he is upgraded from JMFC to senior civil judge to senior judge. So he is a JMFC court and CJM court, Chief Judicial Magistrate. They are available for these economic offense cases, sir, and traffic cases, and now newly Act 2005 domestic violence case, protection from women's harassment by way of Domestic Violence Act 2005. It is the traffic court is entrusted by the notification issued by the Honorable High Court at Bangalore, and other courts, the JMFC only dealing with domestic violence cases.
Sure, thank you, sir.
Welcome, sir. What about Geeta Rai, Navya? Some ladies are the Priya. How
Sir,
you?
I already spoke, sir.
Thank you.
Sir, I just have one question, sir. Like, can the judge who is as a appointed as a civil judge, can he be appointed as a criminal judge also, sir? Can he pass any sentence?
Wherever rural side, madam, morning they will call the civil cases and immediately they will call criminal cases. Both. He is acted dual role, magistrate as well as civil judge court at rural side. JMFC, Judicial Magistrate First Class. That is the designation of those court. Within 3 years of punishment going to impose, those cases are tried by the same judge. That is called as civil judge and JMFC. Wherever if any order passed from rural side, automatically their designation not only civil judge, but also JMFC is also available.
Thank you, sir.
Welcome. I think all of you understood what are the jurisdiction is available in Bangalore city and rural side, pecuniary, appeals, how the appeals going to file, and what are those facts and circumstances you have to deal with. So important, please note down, nobody is, you are also equal to me, because tomorrow you are coming saying that, sir, you are also LLB, I am also LLB. Only the experience is criteria, knowledge is criteria. If knowledge is not available, you see several cases why we are going to get down for the cases because of these type pecuniary jurisdiction, they are not aware and filing the cases. It is very, I am come across so many cases, therefore I am telling to you, tomorrow such irregularity should not be happen. Therefore I am providing all this new, every week I am changing the, because of subject wise, you must learn something, and tomorrow you come forward and you get the knowledge, and any clarification you want, you come or you ask our principal who is coming to our office. Venkatesh is coming, Mr. Abhilash is coming. You ask them, sir, this is the problem I am facing. So if you want to collect, you will note down. And one thing is sure, because you are attending the moot court. Is it so? While moot court, when you are attending in college, just yourself, imagine you file a case, just because I have given particulars to you, or just you keep in mind, simply sit and question yourself, what case I want to file, recovery suit and property suit. You prepare yourself, and defense is also available on other side. Let them defend that case, how they want to defend, and prepare the pecuniary jurisdiction also. And you can address the argument in moot court also. It is easy for you.
Yes, Lokesh, you have a question, please ask.
Mr. Lokesh.
ಸರ್ ನಮಸ್ತೆ ಸರ್.
ನಮಸ್ತೆ.
ಸರ್ ಒಂದು ಕ್ವಶನ್ ನನಗೆ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಾಗೆ.
ಹೇಳಿ
ಸರ್, ಇವಾಗ ತಂದೆಯವ್ರದ್ದು 3 ಪ್ರಾಪರ್ಟಿ ಇರುತ್ತೆ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತು.
ಹೌದು.
ಮತ್ತೆ ತಾಯಿಯಿಂದ ಬಂದಿರುವಂತ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ.
ಹೌದು.
ಸೊ ಇವಾಗ 3 ಮಕ್ಳಿದ್ದಾರೆ. ತಾಯಿಯಿಂದ ಬಂದಿರುತ್ತಲ್ಲ ಆ ಪ್ರಾಪರ್ಟಿ 3 ಜನಕ್ಕೆ ಭಾಗ ಕೊಡ್ಬೋದಾ?
ತಾಯಿಯವರು ಇದ್ದಾಗಂತೂ ಸಾಧ್ಯ ಇಲ್ಲ, ಒಂದೇದ್ದು.
ಓಕೆ.
ಆಮೇಲೆ ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಫಸ್ಟ್ ಸೆಕ್ಷನ್ 14 ಅಟ್ರಾಕ್ಟ್ ಆಗತ್ತೆ. ಸೆಕ್ಷನ್ 14 ಆಫ್ ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, ವಾಟ್ ಎವರ್ ಪ್ರಾಪರ್ಟಿ ಬಿಲಾಂಗ್ಸ್ ಟು ದ ಮದರ್, ಇಮಿಡಿಯೇಟ್ಲಿ ಇಟ್ ಗೋಸ್ ಟು ಡಾಟರ್. ಇಫ್ ಡಾಟರ್ ಈಸ್ ನಾಟ್ ಅವೈಲಬಲ್, ಆಟೋಮೆಟಿಕ್ಲಿ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಗೆಟ್ ದ ಪ್ರಾಪರ್ಟಿ.
ಇವಾಗ ಮಗಳು ಬೇಡ ಅಂದ್ರೆ ಸರ್?
ಮಗಳು ಬೇಡ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಹೋಗುತ್ತೆ, ಎಲ್ಲದೂ ಹೋಗೋದಲ್ಲ. ಇಮಿಡಿಯೇಟ್ಲಿ ಸ್ವಲ್ಪ ಹೋಗುತ್ತೆ. ನೋಷನಲ್ ಪಾರ್ಟಿಷನ್ ಅಂತೀವಿ ಅದಕ್ಕೆ, ನೋಷನಲ್ ರೈಟ್.
ನೋಷನಲ್ ರೈಟ್ ಅಂತನಾ?
ನೋಷನಲ್ ರೈಟ್ ಅಂತೀವಿ ಅದಕ್ಕೆ. ನೋಷನಲ್ ಕ್ಲೇಮ್, ನೋಷನಲ್ ಕ್ಲೇಮ್ ಹೋಗುತ್ತೆ ಅವ್ರಿಗೆ. ಸೆಕ್ಷನ್ 14 ತೆಗೆದು ಓದಿದ್ರೆ, ಟು ಹೂಮ್ ದೋಸ್ ಪ್ರಾಪರ್ಟಿ ಹ್ಯಾಸ್ ಟು ಗೋ, ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ 2005.
ಓಕೆ ಇನ್ ಕೇಸ್
ಆಮೇಲೆ
ತಾಯಿಯವರು
ಮದರ್ ಕೂಡ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಇಟ್ ಈಸ್ ನೋಡಿ ಮದರ್ಗೆ ಯಾವ್ಯಾವ ಪ್ರಾಪರ್ಟಿ ಬರ್ತಾವ ಅನ್ನೋದು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಒಂದೇದು ಗಿಫ್ಟ್, ಒಂದೇದು ಅವ್ರ ತಾಯಿಯಿಂದ ಬಂದಂತದ್ದು ಪಾರ್ಟಿಷನ್, ಆಮೇಲೆ ಮೇಂಟೆನೆನ್ಸ್ ಪರ್ಪಸ್ ಆಗಿ ಬಂದಂತದ್ದು. ಇವೆಲ್ಲ ಪ್ರಾಪರ್ಟಿಗಳು ಇಂಡಿಪೆಂಡೆಂಟ್ ರೈಟ್ ಇವು ಅವರಿಗೆ. ಅವ್ರು ಯಾರಿಗ್ ಬೇಕಾದ್ರೂ ಕೊಟ್ಟು ಹೋಗ್ಬೋದು. ಈವನ್ ಪಾರ್ಟಿಷನ್ ಇದ್ದ ಬಂದ್ರು ಕೂಡ ಕೊಡ್ಬೋದು, ಮೇಂಟೆನೆನ್ಸ್ ಬಂದರೂ ಕೊಡ್ಬೋದು, ಗಿಫ್ಟ್ ಬಂದ್ರು ಕೊಡ್ಬೋದು, ಯಾರಿಗ್ ಬೇಕಾದ್ರೂ ಕೊಡ್ಬೋದು. ಮದರ್ಗೆ ನೀವು ಅವ್ರ ಹಕ್ಕದಾರಿಕೆನ ನೀವು ಕೇಳಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ನೋಡಿ ನಿನ್ನೆ ಒಂದು ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೀನಿ, ಸೇಮ್ ಕೇಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿದೀನಿ. ನೀವು ನಿನ್ನೆನೆ ಅಡ್ರೆಸ್ ಮಾಡಿದ್ರು, ನಾನು ಅಡ್ರೆಸ್ ಮಾಡಿದೆ. 3 ಚಿಲ್ಡ್ರನ್ ಇರ್ತಾರೆ, 3 ಗಂಡ್ಮಕ್ಳು, ಒಬ್ಬವನು ಸತ್ತು ಹೋಗ್ತಾನೆ. ಅವಾಗ ಈ 3 ಜನ ಏನ್ ಮಾಡಿದ್ರು, ತಾಯಿ ಹೆಸರಿಗೆ ರಿಲೀಸ್ ಡೀಡ್ ಬರೆದು ಕೊಟ್ಬಿಟ್ರು. ಸೇಲ್ ಡೀಡ್ 3 ಜನರಿಗೆ ಆದಂತ ಪ್ರಾಪರ್ಟಿನ ರಿಲೀಸ್ ಮಾಡಿ ತಾಯಿ ಹೆಸರಿಗೆ ಬರೆದ್ಬಿಟ್ರು. ನಮಗೇನು ಬೇಡ, ನೀನ್ ಒಬ್ಳೆ ತಗೋ ಅಂತೇಳಿ. ಬಟ್ ರೀಡಿಂಗ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಿತ್ತು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಅಂದ್ರೆ, ನಾನು ಓದ್ದೆ ಅದನ್ನು, ಜಡ್ಜ್ ಮುಂದೆ ಇದನ್ನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ. ವೆದರ್ ಐ ವಾಂಟ್ ಟು ಪ್ರೂವ್ ದಿಸ್ ಇಸ್ ದ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಎ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಆರ್ ನಾಟ್ ಅಂತ. ಅಲ್ಲಿ ಏನು ವರ್ಡಿಂಗ್ ಇತ್ತು ಅಂದ್ರೆ, ಸೇಲ್ ಡೀಡ್ ನಲ್ಲಿ, ರಿಲೀಸ್ ಡೀಡ್ ನಲ್ಲಿ, ನಮಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದಂತ ಹಕ್ಕುದಾರಿಕೆಯಿಂದ ಖರೀದಿ ಮಾಡಿದಂತ ಪ್ರಾಪರ್ಟಿ ಒಂದು ವರ್ಡ್ ಇತ್ತು. ನಾನು ಅದನ್ನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ, ವೆದರ್ ಇಟ್ ಈಸ್ ಎ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಆರ್ ನಾಟ್, ಬಿಕಾಸ್ ಆಲ್ ದ 3 sons while releasing the right in favor of mother, because of this is one reason. Second reason, they have shown this property is not divisible property, therefore we are executing release deed. Not divisible andaga still we are having partition, therefore it is divisible, it is a joint family property anta argument ಮಾಡಿದೆ. ಜಡ್ಜ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಮಾಡಿದ್ರು, ಮತ್ತೆ ಪಾರ್ಟಿನ ಕರೆಸಿದ್ರು. ಯು ಸಿ ಟುಮಾರೋ ಆರ್ಡರ್ is going to be passed, though you are absolute owner of the property, because sons are executed release deed in your favor, section 14 is attracted, but recital of the said document, release document, automatically it says it is a joint family property. ಈ ತರ ಬಂದಾಗ ಡಾಕ್ಯುಮೆಂಟ್ ನ ಕ್ಲೀನ್ ಆಗಿ ಓದ್ಬೇಕು ತಾವು.
ಸರ್ ಇನ್ ಕೇಸ್ ಹಲೋ ಸರ್, ಆ ಪ್ರಾಪರ್ಟಿನ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಇದ್ರಲ್ಲ, ಆವಾಗ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿರ್ತಾರೆ
ಹೌದು
ಎಲ್ಲರೂ ಒಟ್ಟಾಗಿ. ಸೊ ಇವಾಗ ಅದು ಕಾಲೇಜ್ ಸೈಟ್ ಅಲ್ಲಿ,
ಹೌದು
ಹಲೋ
ಹೇಳಿ,
ಕಾಲೇಜ್ ಸೈಟ್ ಇರ್ಬೇಕಾದ್ರೆ ಇವಾಗ ಅವ್ರ ತಾಯಿಯವ್ರ ಡೆವಲಪ್ಮೆಂಟ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಇವಾಗ ಮಗಳಿಗೆ ಮಾತ್ರ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬೋದಾ?
ಸರ್ ಡೆವಲಪ್ಮೆಂಟ್ ನ ನೀವು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಯಾರಂತ, ಅಮ್ಮನಿಗೆ ಆದಾಯ ಇರ್ಲಿಲ್ಲ, ಖಾಲಿ ಸೈಟ್ ಮಾತ್ರ ಅಮ್ಮನ ಹತ್ರ ಇತ್ತು, ಅದನ್ನ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿದ್ದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಫಂಡ್ ಇದ್ದ. ಒಂದಂತೂ ಕಾನೂನಿದೆ ಇವ್ರೆ, ಇದನ್ನ ನೋಟ್ ಡೌನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಲೇಡೀಸ್ ಕೆನಾಟ್ ಬಿ ಬ್ಲೆಂಡಿಂಗ್ ಇನ್ ಟು ಕಾಮನ್ ಸ್ಟಾಕ್. ಅವರು ಕಾಮನ್ ಸ್ಟಾಕಿಗೆ ಹಾಕಕ್ ಅಧಿಕಾರ ಇಲ್ಲ, ಹಾಕಿದ್ರು ಕೂಡ ಅದು ಇಂಡಿಪೆಂಡೆಂಟ್ ರೈಟೇ. ಬ್ಲೆಂಡಿಂಗ್ ಇಂಟು ಕಾಮನ್ ಸ್ಟಾಕ್ ಅಂದ್ರೆ ಥ್ರೋಯಿಂಗ್ ಇಂಟು ಕಾಮನ್ ಸ್ಟಾಕ್. ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಈಗ ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಪ್ರಾಪರ್ಟಿ ನಂದಿದೆ, ನಾನೇನ್ ಮಾಡ್ತೀನಿ, ನಾವು ಗಂಡಸರು ಮಾಡ್ಕೋಬಹುದು ಥ್ರೋಯಿಂಗ್ ಇಂಟು ಕಾಮನ್ ಸ್ಟಾಕ್, ಆಮೇಲೆ ಡಿವಿಷನ್ಗೆ ಹಾಕೋತೀವಿ. ಲೇಡೀಸ್ ಏನಾದ್ರು ಇಂಡಿಪೆಂಡೆಂಟ್ ಟೈಟಲ್ ಇದ್ದಾಗ ಅವ್ರು ಬ್ಲೆಂಡಿಂಗ್ ಅಂತ ಬರೋದಿಲ್ಲ. ನೀವೇನ್ ತರಬೇಕು ಅದಕ್ಕೆ ಅಂದ್ರೆ, ವಾಟ್ ಎವರ್ ಡೆವಲಪ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಮೇಡ್, ಇಟ್ ಈಸ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಶಾಲ್ ಬಿ ಡಿವೈಡೆಡ್ ಅಮಾಂಗ್ ಅಸ್ ಅಂತ ಹೇಳ್ಬೋದು. ಅಲ್ಲಿ ನೋಡಿ, ನಾವು ವರ್ಡ್ ಹೇಗ್ ಉಪಯೋಗ ಮಾಡ್ತೀವಿ ಅನ್ನೋದ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಒಂದು ವರ್ಡ್ ಬ್ಲೆಂಡಿಂಗ್, ಮದರ್ ಹ್ಯಾಸ್ ಥ್ರೋನ್ ಇನ್ ಟು ಕಾಮನ್ ಸ್ಟಾಕ್, ಮದರ್ ಹ್ಯಾಸ್ blended her ownership property into the joint family property. ನೀವು ಅಂದ್ರಿ you are failure, because there are several decisions. She cannot blend to the common stock. ಕಾಮನ್ ಸ್ಟಾಕ್ ಅಂದ್ರೆ ಒಗ್ಗೂಡ್ಸೋದು, ಗುಂಪೆ ಹಾಕೋದು. ಹೆಣ್ಮಕ್ಳಿಗೆ ಆ ಹಕ್ಕುದಾರಿಕೆ ಕೊಟ್ಟಿದ್ರು ಕೂಡ ಅವಳು ನಾನು ಕೂಡ ಅದ್ರ ಜೊತೆಗೆ ಸೇರ್ಕೋತೀನಿ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ಅದು ಇಂಡಿಪೆಂಡೆಂಟ್ ಪ್ರಾಪರ್ಟಿನೇ, ಅದಕ್ಕೆ ಜಜ್ಮೆಂಟ್ ಇದೆ. ಅದಕ್ಕೆ ನಿನ್ನೆ ನಾನು ಜಡ್ಜ್ ಮುಂದೆ ಇದನ್ನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿತ್ತು. ಐ ಬೀಯಿಂಗ್ ಎ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಡ್ವೊಕೇಟ್, ಐ ವಾಂಟ್ ಟು ಬ್ರಿಂಗ್ ಟು ಯುವರ್ ನಾಲೆಜ್ ಸೇಯಿಂಗ್ ದಟ್ she has no right to blend the property, but release deed has been executed by my children who are having title to the property earlier, and they have stated the recital, it is a joint family property ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ. You are not the owner. ಹೀಗೆ ಮಾಡ್ಬೇಕು. ಫೈನ್
ಸರ್ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸೈಟೇಷನ್ ಏನಾದ್ರು ಇದೆಯಾ?
ಬೇಕಾದಷ್ಟು ಕೊಡ್ತೀನಿ, ಬಂದ್ರೆ ತಗೊಂಡು ಹೋಗಿ.
ಓಕೆ ಸರ್. ಓಕೆ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ವೆಲ್ಕಮ್ ಸರ್. ಎನಿ ಕ್ವಶನ್?
Sir,
ಹೇಳಮ್ಮ.
similar to what Lokesh just asked, I just want to understand. So what if it is something that is acquired as in after the spouse passes away and the lady acquires, and she's got 3 sons. In that case, how does it happen? She can still do whatever she wants? I mean, it's self-acquired property by the spouse.
Madam, one thing is this. You first ascertain yourself whether she has acquired the property through her own fund, or whether this property, how title is derived by her. That
Okay,
two
it is on the passing of the husband, it has come to her. So she has got
No.
sons.
Now, after husband passed away, means it is husband's property if it is, because one thing is happened. Every day the Bangalore problem is like this. What happened? Immediately passing of the husband, whatever property title stands in the name, immediately the mother going to get it affects the Khata, and Kandaya is also paying by her. Khata in her name alone, Khata is available in favor of mother. What our law says, Khata, Kandayam, whatever she has paid and whatever you got it affected, those Khatas are not going to be decided title to the property. Likewise, the same thing applicable, because she is not the owner, we are also owner, because 35 years of the one of the property at Jainagar, I have filed a suit before this honorable court stating that last 35 years since she is enjoying by getting change the name of her husband in her name and absolute ownership, what she has did, the property was immediately got it registered in the name of one of the son by executing the gift deed, but title stands in the name of husband, and she has gift away to the son, and immediately other son questioned that gift deed. Automatically they have come forward for partition, because she has no manner of right to execute, because it is property of her husband. So it is not, she is also entitled equal share along with other family.
Yeah, her share she can give to anyone if she wishes.
Yes, definitely. Now you see, always you must advise the partition suit. One thing you have to advise to the people, saying that why unnecessarily fighting, because it is beneficial to the advocate only, because property is available there only, and fighting for partition. You must advise, if you want to sell the property, undivided interest, madam, what is the recital in the sale deed? You can alienate your right, which is undivided interest, you can alienate to anybody else, and you are also party to the for partition suit if you want to alienate your portion. And who is going to purchase the property? He is a man of claiming the partition, and he can file a suit against them who got the right over the property. Undivided interest. If 1/4 is available, 1/4 I want to purchase the property, I have to file suit against other 3, stating that I have already purchased his share, so I am entitled, one share should be identified from that property. Undivided share also you can impose, because immediately he want money and immediately he want to go to abroad, so they are not ready to sell the property, so therefore he can sell his undivided share. Undivided interest he can alienate, and those who are purchaser, they can file the suit against other 3. This is also available. You have to advise the people while partition, is there any person coming forward to alienate their independent share who are eligible from this property? You first ask them, then you file a suit for partition. It is better this.
Yeah, thank you so much, sir. Is this also applicable to factory lands? I mean,
Everything, madam, everything. Now you see limited, wherever limited company, because it is family company is there, automatically the benefit, profits, everything is described in the bylaws of the company, rules and regulation of the company and firm.
Okay, what if one of the sons was the managing director during the father's time? And in that case, does that change the rules by any chance, or will
Yes,
it still
madam.
be done?
Because, madam, it is only understanding. The same thing is happen in one case. The school is running by one of the son at RT Nagar. That is the case I have dealt. And other children, they want to interfere in the school affairs. He is not permitting them. Then it is a joint family property. He is alone managing director of the school. And every year, I think you must know that now my college is running by Advocates Education Society. We are the organization, and all the staffs are appointed through our society only. So likewise, what happened? One of the son is managing director of our organization, and he wants to run the school college. So nobody is going to be interfere other children. So it is very difficult for them what they have to do. Then immediately the children are started seeking for partition in respect of property, not for the school. It is very difficult for you because it stands in the name of always society, because society has got the permission for run a school. The same thing in law college also, the same thing, running under the society. Permission has been granted in favor of society.
Okay, so this, as far as I understand, this is different when it comes to a company holding, right? When it is a public limited organization.
Yes, public organization, it is very difficult, madam. Public organization, public company, public
Sorry,
charitable.
not public. I meant to say private limited organization.
Yes, only private limited organization you can claim, madam.
Yeah, okay, sir. Okay, but still it is considered as a self-acquired, passed on to the sons if it was in the father's name.
Yes,
right?
yes,
Yeah.
yes.
Okay. I understood, sir. Thank you so much.
Welcome.
Sir, last question from my end. Sorry to interrupt, sir.
Please.
Sir, what is this single bench, divisional bench? I mean, if single bench order can be challenged to the divisional bench, or we can directly go to the High Court, the Supreme Court.
There are writ judice. RFA you cannot. RFA you cannot go before the second bench, because RFA is independent. You see, RFA based on the pecuniary jurisdiction. Within 10 lakhs, wherever the valuation is available, it is going before RFA. That is permanent injunction suit, recovery suit within 8 lakhs or within 10 lakhs. It is single bench only directly. If failure, you have to move before Honorable Supreme Court only. Bench is always available for pecuniary jurisdiction. This is civil, I am telling you. Writ jurisdiction, if single bench order passed, appeal we are going to file before the bench. And KAT order, Karnataka Administrative Tribunal order, only before bench. Central Administrative Tribunal order, only bench. Because the retired High Court judges are dealt with those matters before CAT, before KAT, Karnataka Administrative Tribunal, that is relating to service matters. So only those writ petitions are having jurisdiction only before bench only. And even family court is also. Family court always before bench, sir. Final order, always bench. And other orders, on IA orders, only the single judge dealing with.
Okay, sir. Thank you so much.
Welcome, sir.
Okay, we will end the session. Thank you, everyone.
Thank you, sir. Good night.
Thank you, sir.
Thank you. Good night.
Bye-bye.
Thank you, sir.
If you are not